Hello, thank you so much for joining us this evening. I appreciate you for joining us on this here in Chicago, very gloomy Tuesday evening, where we are going to talk about the first 48. What happens the first 48 hours after people die and how you can prevent that and make it better for your family and yourself. I am Ebony Lucas. I am a real estate and estate planning attorney. I help people build wealth through real estate and keep it through estate planning. I appreciate you joining me this evening, and we are going to go ahead and get started. Next slide, please. So most families think that grief is the hardest part, but it's actually the chaos. So I just want you guys, you know how you have the reactions. Tell me if you've experienced and seen this happen when someone passes away. You're notifying family and friends. You have your bank accounts that you can't use anymore. You got to figure out what the life insurance is. You're deciding who's making and paying for the funeral arrangements. You're searching through mail, finding creditors. Have any of you experienced any of these? Come on, give me some reactions. Tell me yes or no you've experienced these. Meanwhile, somebody's asking, who's getting the house? And everybody thinks that's such an inappropriate question because somebody is always asking that way sooner than they should be asking it. So we're going to talk this evening about how you avoid that situation, what you can do to make sure you protect your assets and make sure that your family doesn't end up in this type of chaos. Next slide. I want to just debunk one myth, and that myth is estate planning is not just for rich people. A lot of times we hear estate planning and we think, oh, that's not something for me because I don't have enough. I don't have anything to pass down. But tell me if you own a home. Put it in the comments, raise your hand, give me a reaction. Do you own a home? Do you have a life insurance policy? Do you have a retirement account? Do you have a business? Do you have an investment property? If you have any of these things, you already have an estate. You might just have a home and you're like, oh, all I have is my little home. But your little home is valuable to somebody. Your business is valuable to somebody. Your retirement accounts have money in them that you may not spend during your lifetime. All of these things are things that you want to make sure that you protect. And let me tell you something, it's not just these big things that we're thinking about, but how many of you have experienced or seen when someone passes away and people are fighting over the holiday china? That's the china we only take out on the holidays. That's special to people. It means something to people, even though it has a sentimental value. It is part of someone's estate and it means something to the family. And therefore, people will fight about it. People will wonder what's going to happen to it. People will ask for it after someone passes away. People will ask for that Michael Jordan shoe collection. Come on now, who has all of the Jordans? Somebody's going to ask for that. They're going to ask for the flat screen TV. All of these things are a part of your estate. And a lot of times we don't think about it like that. But if you own any of these things, yes, you have an estate. And if you own those things and don't have an estate plan, guess what? There is still a plan for you. There is a plan for people without a plan. What does no plan mean? No plan means court. Guardianship. I'm going to take a moment to talk about guardianship because there are 2 movies out right now on Netflix. One of them is called Bad Guardian. Have any of you guys seen that movie, Bad Guardian? And Bad Guardian is a scary true story about this lady who was on vacation with her family. Her father fell. He called 911. He went to the hospital. They couldn't contact a family member, so they appointed a guardian. She gets back. And when she finds her father, they put him in a home and she can no longer speak for him. The guardian sells the house and takes all of the money. This is reality. This happens. I've seen situations where judges have been a part of this whole situation where they will allow these guardians to take actions on behalf of your loved ones because there's nothing in place. So you want to make sure you have something in place that says that if something happens to you when you're alive, that you don't want a guardian appointed unless it's somebody you appoint. Part of what we're talking about today is how do you maintain control over your life and your assets that you've worked for, both during your lifetime and after you pass away. And that control helps you to stay comfortable even if you become incapacitated, or even if you have a brief time where you can't handle your business. You get into a car accident, you have a heart attack or a stroke. How do you make sure that your family stays in control and that your assets are not lost, forcibly sold? And so that next thing that we talk about is forced sale of assets, that there's no delays so that your family can access your bank accounts and pay your bills if something happens to you, so that all your business is not out in the public records. Let me give you a good story about that because Michael Jackson is hot right now. Michael Jackson had a will, what's called a pour over will. And he had a trust, but his trust was never funded. You're not going to do that because tonight we're going to talk about and make sure that your trust is funded. But Michael Jackson had this trust in place and he had a pour over will, but his trust was never funded. It cost them millions of dollars. They spent 16 years in probate. It's crazy, right? You want to make sure that that doesn't happen to you. And also, everybody doesn't have to know about your business and what you have and what you didn't have. And so one way to keep it private, we're going to talk about tonight. Family disputes. I can talk about from personal experience about how someone's death causes family disputes. And a lot of it is because grief is actually considered a mental illness. It is part of mental illness. Grief is something that mentally impacts you in a way that impacts your mental wellness. And so you make decisions during grief that you wouldn't make if you weren't in that space. So family disputes, frozen assets, lost assets. We're going to be talking about tonight, how do you protect yourself from all of that? The path to protection. We want to protect ourselves, number one, when we're alive. We want to protect our children, our family members that we're caring for that have special needs. We want to transfer our wealth efficiently and without losing money. We don't want the next generation to start over. And we are facing right now what they call the Great Wealth Transfer. What that is that one of our biggest populations right now, the baby boomers, are aging. And as they age, they are transferring trillions of dollars of wealth. And we are unprepared for that. And that is because less than 30% of Americans, the exact number, this is a little off, the exact number is 24%. Only 24% of Americans have an estate plan. Why don't we have estate plans? Fear, difficult conversations that we don't want to have, mistrust, lack of information, and procrastination. Which one of these are you guys? Tell me what you are. Talk to me a little bit in the comments. Is it fear? Is it difficult conversations? Is it mistrust? Is it lack of information? Is it procrastination? What has stopped you so far from getting your estate plan in place? Yes, fear. I get it. I get that fear. Thinking about death, thinking about not being in our own capacities. Stubbornness. Yes, that's a great one. Stubbornness from seniors, but there's a reason why they're stubborn. They're stubborn because of mistrust. They're stubborn because of fear. Absolutely. Procrastination, knowledge, money. A lot of people say they don't have money to do it, but we'll talk about that. One of the things that we need to really start doing more of is collective economics, right? So if you see that your grandmother's house is starting to fall apart a little bit, can you and your family members come together and say, hey, we know that this is part of our legacy? A lot of times we don't think about that. we're like, oh, well, that's just where she lives and that's her responsibility. But at some point, it's going to be passed down to you. So how can your family members get together and pool your resources? So if you don't have enough money, those people who can benefit from it can actually come together and say, hey, can everybody put in $100? Can we put in $20 a month each so that we can pull together enough money to make sure that grandma has an estate plan, so when she passes away, our family doesn't go into chaos and we know what's going to happen to her home. Let's start thinking outside of the box and not letting money be something that stops us, but instead think about how we can come together in cooperative economics. And basically, those of us who are supposed to actually inherit these items are the ones that should be coming together to try to make sure that we're paying for these items. Procrastination, cost, priorities, all of that. Yes, all of those things are things that impact us in our decisions. So now, no more can you say lack of information. You can't say that anymore, because tonight you're going to get the information that you need. We're going to talk about wills versus trusts. One thing, if you follow me on social media, you've heard me say, is that a will is an instruction to the court. How many of you have family members that have a will? A will is an instruction to the court. What does that mean? I'm going to give you an example. My grandmother passed away last year. She was 95 years old. She lived a wonderful life. Not only did she live a wonderful life, but she left a legacy. Her and my grandfather owned a condo in Florida. They had some stocks in Mercedes-Benz and Chrysler because he was retired from Chrysler. They had some money in the bank. They had some CDs. They had all of these different assets that they pulled together and they put them in a will. Now, when my grandmother passed away, that will named my mom as the executor of the estate. A lot of times we think, okay, well, I'm the executor of the estate, so everything's fine. Everything's taken care of. When the person passes away, I'll just be able to take care of their business. Wrong, 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 wrong. What happens if they have a will is that you now have to go to court, and some courts, there's just a form you fill out. If the assets are less than $100,000 in Illinois, there's just a paper that you fill out and you file the will with the court. But either way it goes to court. And those papers that you fill out are probate. So I posted about this and people were like, all wills don't go to probate. All I had to do was go to court and fill out a paper. That paper is probate, okay? The paper that you fill out in court is probate. That building that you go to fill out that paper is court. The fees that you pay are court fees. So understand that if you have a will is an instruction to the court. That means you have to go to court in order to access anything. What happens with the will? So going back to the situation with my grandmother, because her assets were more than $150,000, they have to now get a judge to sign off to say, yes, I reviewed this will and I think the will is valid. It took from August to 2 weeks ago for the court to sign a paper agreeing with what my grandparents had already put in place. What did that mean during that time? And when I said that a will costs $15,000 to probate, people were like, no, it doesn't. Well, let me tell you what costs more than $15,000. They owned a condo. They had to pay monthly HOA fees. They had to pay for the lawyer because the property's in Florida and they're in Michigan. They had to pay for the property taxes. They had to pay for utilities in the property. They have to pay for somebody to go over there and just check on the property every once in a while to make sure everything is okay. All of those things cost money and it adds up. And not only that, those long wait times, if you do it yourself, could mean that you have to take off days from work. So let's not just add up the $600 that you have to pay the court. Let's add up your time, because time is money, right? How many of you agree that your time is money? If you have to go to court, if you have to take off work and you're not being paid for work because you need to go to court, that is money. So that's what happens when you have a will. A will is not effective until somebody dies, and then after they die, you have to go to court. If you have a special needs child, or if you have a child that's a minor, if you have a family member you're taking care of, the court gets involved and gets to name guardians. People have to decide who's going to take care of who. All of that happens if you have a will in place, unfortunately. It's costly in the end. So I put here that there's lower upfront fees. Well, yeah, if you have a will, you don't have to pay to transfer the deed into your trust because you don't have a trust. So your deed is still in your name your whole entire life, and somebody has to go to court in order to get it transferred. Ultimately, the will in the end costs money. A trust, on the other hand, a trust avoids probate. What does that mean? If you have a trust in place and your trust is properly funded, and we're going to talk about what funding means. This is what I told you about Michael Jackson's trust. Remember, I told you that funding means that once you have a trust, you then make sure that there are things in the trust. So you have to transfer the deed to the trust. You should make the beneficiaries of your life insurance policy and your bank accounts should be the trust instead of individuals. That is how you fund the trust. You make the trust the beneficiary. You place your property into the trust. Doing this allows your business, your financial business, to remain private and amongst just your family. It's effective during life. So in your trust, you can say, if I get ill and I become incapacitated, this is my trustee. This is who I want to take care of my business. Nobody else can take care of my business. You can't do that with a will. A trust tells how you want your assets to be controlled. I want this person to get this. I want my child to get this. I have one recently, where my client said, when my grandchildren graduate from high school, if they are going to college, then I want them to get $10,000 from my trust. That's money that they get automatically from the trust, from her bank account, if they graduate from high school. You can put those types of things in there. You can put other restrictions in there. Trust allow you to put things in there about mental illness. If you have a family member that's mentally ill and you don't think that they're going to have the capability to take care of it. Okay, I don't think they're going to have the capability, but I want to name this person to make sure that they take care of my family member. Make sure my family doesn't blow the money. If you have a family member with addiction, you can say, hey, I will set aside this amount of money if they go to rehab. If they don't go to rehab, they don't get the money. All of those types of restrictions you can put in a trust and give people something to look forward to. Help people to remember you. A trust controls how your assets are managed. It does require funding, which means, yes, you're going to have to pay to record your deed. In Illinois or either in Cook County, it's $108. So we're not talking about a huge difference in cost, but we are talking about a huge difference in protection because a will instructs the court and a trust provides a system. Next slide, please. So let's talk about common mistakes because I'm sure people are like, well, I had a person and they had a trust and this happened, or I had a person and they had a will and this happened, right? So there's always exceptions to the rules, right? But here are just some common mistakes that people make that result in, like we talked about in the beginning, that first 48 chaos. Leaving minors as beneficiaries. What happens if you leave a minor as a beneficiary? Does anybody know? Tell me in the comments if you know what happens if you leave a minor as a beneficiary. Does anybody know what happens? So, yes, they have to be 18. They can't get the funds. They need a guardian. All of the above. They can't do anything until they're of age. All of the above. That is exactly what happens. If you make a minor a beneficiary and they are not 18 at the time of your death, they cannot collect the funds. So what happens is that So they're family members. So a lot of people say, well, just leave them as the beneficiaries. You don't need to do a trust. Okay, well, now your family members have to go to court. And then the court has to appoint somebody. That person has to have a bond. There are requirements to have a bond. A bond costs money. So now you actually have to pay money to get the money. So we don't want to leave our minors as beneficiaries. We want to leave our minors in a trust with a trustee who can get the money immediately to take care of our children. Thinking a will avoids probate. Well, I beat that one with a stick, right? I told you guys that a will is an instruction to the court. You have to go to probate, even if it's just going to probate to fill out a piece of paper. In Chicago, you have to pay $18 just to go park, and that's for 2 hours to go fill out the paperwork. So when people say, oh no, it only cost me $200, well, how much did gas cost? How much did parking cost? How many days did you have to take off work? Let's talk about all of those costs that it costs to have to go to court to probate a will when it was unnecessary. Not updating beneficiaries. I'm gonna tell you guys a funny, not so funny story, right? I had a client who was dating this guy. She was with the man for, I think it was like 30 years. They had been together for a very long time. But when they met, he was married. He had had an affair. His ex-wife was still named as a beneficiary on his bank accounts. She was married though. And she thought, well, I'm married, whatever. They never looked at the beneficiaries. When he died, we had to then contact the ex-wife to say, hey, you are a beneficiary on this bank account. You think the ex-wife is going to give the lady who her husband cheated with any money? Nope, she's not. There's a whole lot of lessons in that story. However, the big one is make sure the beneficiaries are updated, because it doesn't matter if you're married, remarried. It doesn't matter if you have kids. A lot of times people think, oh no, well, that will override it. It will not. So make sure that you're looking at your beneficiaries. Make sure your accounts have a beneficiary in the first place. Every brokerage account, every bank account, every retirement account should have a beneficiary. Ideally, that beneficiary would be your trust. Another thing people say, well, just put the kids on the title. So you put the kids on the title, the kids go to college, they get a bunch of credit cards, and they run up those credit cards, and a collection agency comes. Guess what that collection agency can do? Put a lien on your house. That's why we want to make sure that we don't just put people on our title. Having no incapacity plan. A lot of people have a plan for death, so you have a will in place, but you don't have a power of attorney. You don't have a healthcare power of attorney. You don't have a durable power of attorney, which covers financial. You don't have a plan for if something happens to you. If you own a business, I saw some people in the comments who own businesses. If you own a business and you get into a car accident, what's going to happen to your business? Who's supposed to contact your customers? Who's supposed to pay your bills so you don't get kicked out of your commercial space? You need a plan for that. And the plan has to be in writing, because the one thing that we don't have on here is a common mistake or a common myth that people have is, and I literally just had this conversation last week with a guy. His best friend passed away and left the vehicle. And he said, well, my best friend promised me that vehicle. He told me that I could have that vehicle. Well, you can't have it if your best friend didn't write it down. And it was a sad conversation to have. He said he even gave me an extra key and said that if anything ever happened to him, the vehicle was mine. But his best friend never put it in writing. So he can't have the vehicle. It doesn't matter what people's intentions are, what people say, what people promise you. If they promised it to you and it's not in writing, when they pass away, it will not be yours. Assuming the family will work it out. Oh, I'm not going to worry about that. They'll work it out when I die. People who get along perfectly fine have huge falling outs after someone dies. And it is not because they care about the items, it is because of grief. It's because they care about the person. And sometimes belongings make people feel like they're still close to the person who passed away. And so people will act in a way that they normally wouldn't act, not because they care about the shoes or the hats or the sweater or the jacket or the furs. They don't really care about those. Sometimes they care about those things, but sometimes they don't really care about those things. At the end of the day, what they care about is the person, and that person is gone. So their behaviors are irrational because grief is an irrational behavior. Having life insurance, two things: life insurance with no beneficiaries, life insurance with old beneficiaries. If you have a beneficiary and that beneficiary passed away, you want to change your beneficiary. Life insurance with no beneficiaries, old beneficiaries is an issue. Your trust, however, if your trust is the beneficiary of the life insurance, then even if someone passes, there's a plan. And then finally, we talked about having a trust and not funding it. Do we have any questions? I've been talking a lot, so if you have questions, feel free to put those questions in the chat. I'll just take a moment. How about we take a moment? If you have questions, I'm gonna allow people to raise their hand and we'll let some people ask questions. Great question. Somebody said, "Why don't we know this?" Yes, I mean we know it now. We're getting the information now, but it does need to be a lot more. And this information does need to be a lot more prevalent. Aaron, yes, Aaron. Aaron, you can unmute and ask your question.
Okay, there it is. Good evening, everyone. So I have a life insurance policy that I just started, and they gave us a trust. But I don't know, like I don't even know if it's what type of trust it is, like if it's a revocable or irrevocable. And then, I mean, it's just basically just answering some questions to set it up. But should I still consult with an attorney like yourself to go through that process, or is that something I should do on my own? Hayete.
Absolutely, I would recommend that you have legal advice through this process because there are a variety of different types of trust, and we haven't gotten into it, but there are, as you mentioned, a revocable living trust, an irrevocable living trust. There are, when we talked about if in an irrevocable trust, you can actually protect your assets from some creditors. You can make sure that your house can't be forced sold if you have to go to a assisted living facility. There's ways that you can protect your property in an irrevocable trust. So that's something you might want to do with your primary residence. However, you can't benefit and you can't be the trustee of your irrevocable trust. On the other hand, if you want to have you may want to have a revocable trust for any assets that you may sell, like an investment property. So there's a variety of different type of trusts. I would be very careful. Like somebody sent a message saying that they had an international, some type of trust that I never heard of. I mean, there are things that courts recognize and that also, more importantly than courts, that banks recognize. So you want to make sure that whatever document that you have is going to be recognized by the institutions that that your family needs to take it to. So definitely if at a minimum, you should be meeting with an attorney to determine your particular situation and the best structure for you. And then if you decide, hey, I want to do it myself now that I know what the structure is, then you can go off and do it on your own.
Okay. Yeah, because like I said, we opened it up with Ethos and they provided us Ethos or True Stage. But yeah, they provided us. So I do have a business. My car is paid off. So I do want to get all of those things over into the trust. But I'm glad you had this session before I was over here, playing around with it and trying to figure it out on my
Right.
own. Yeah.
Exactly. And the other thing is, there's a lot of online sites now that allow you to do the trust. My concern about the online sites is that the online sites don't actually tell you how to fund the trust. And that's sort of part two. It's one thing to have the paperwork, but a trust is just a is just a pile of papers if you don't actually fund it. And somebody asked if I could go into what does it mean to fund the trust. Funding the trust means transferring your deed into your trust. So you have to get an EIN number because a trust is a separate entity. It's almost like if you started a business and you need an EIN number and you have a separate bank account, it's the same type of thing. A trust is going to be a separate entity from you. And in order to make it a separate entity, you actually have to give it some belongings. Well, there's one other question and then we'll move forward.
What happens if a trust is funded and the couple gets divorced?
Okay, if a trust is funded and the couple gets divorced is the question. If you have a trust with your spouse and it is a funded trust and it's a joint trust, usually the joint trust will say how the assets are supposed to be divided. If they don't, then in that divorce, basically those are joint assets. So usually what the court will do is have you formulate separate trusts, and the court will tell you how those assets need to be divided in your joint trust. One of the things that we usually do, especially for couples that have separate assets, so you have a couple, I had a couple that had, one person had assets like a family land down south, and they wanted that to be treated separately. So even as a couple, you can have some joint assets, so you can have a joint trust for some assets and separate trust for other assets. That's the best way to set it up. And in that way, if something were to happen in your marriage, you make sure you don't end up losing your separate assets. Okay, I love this question, Sylvia. All right, Sylvia said she knows some people that have been living in their house for 20 plus years. The home is still in their deceased grandmother's name and has never been changed. What do they need to do? That is such a common situation, Sylvia. You wouldn't believe it. There are people who live in a house and they consider themselves owning the house. They're paying the taxes. They're doing all these other things. And they don't actually own the house because they never transferred the property. The best answer for that is it depends. If there was no will or trust in place, then they may be able to transfer that property via in Illinois, we have what's called an affidavit of heirship. They don't have that everywhere. But an affidavit of heirship, you have to go through all of your grandmother's children and all of their children, so all of your first cousins. You have to say who all of those people are, and all of those people have to sign off. Now, we have people that come to us and they're like, oh no, like I had this family. They came, it was two brothers, and they said, nope, we don't have any other siblings, it's just the two of us. Okay, well then the title company pulls title and we find out that there's 9 of them. How do we find that out? I want you, if you don't remember anything else from tonight, remember this. An obituary is a legal document. Obituaries, number one, should be accurate. You want to make sure that the obituary is accurate. If somebody was like a family member, they were like they were married, they were like a child, but they weren't, they shouldn't be listed as a child in the obituary. The obituary is a legal document. It's a public record. So when the title company pulls title, they then see the obituary. They see the person had 9 children and not 2 children. Now we have to go contact your brothers and your sisters and tell them. And now everybody has to sign off. Now, luckily in that situation, the siblings were a little pissed, but they were willing to sign. You need to be truthful about these things. But in this situation, unfortunately, it's a little complicated. Ultimately, if there are too many people, so if there's 9 people, and I've seen this happen, 9 people, 3 died. Those 3 people have children. Now we had to contact 13 people, but now one of those people died. That person had 5 children. Now we have to contact 18 people. when it comes down where we're contacting too many different people, that's really when you need to go to probate, because it's not going to save you any money. You're going to spend the same amount of money trying to find all these different people as you would just going to probate, filing it in probate. And then once you file it in probate, you have to give notification, public notification, publication in the newspaper, let the family members know. And once you serve everyone, if nobody objects, then you can transfer the property. But most likely in that situation, that, like I said, it depends on how many children, depends on who's deceased and who's not, and whether or not you can reach all those people and do something easier than probate. Usually that situation has to go to probate. And that becomes a very complicated situation in, especially when property is being sold. So if you're a realtor and you have a situation like that, you want to ask them. But I've had situations where we've needed to go to probate, and because we were able to reach all the family members and everybody got along, we were able to get it done in about 4 or 5 months. But 4 or 5 months is a long time to try to keep a buyer waiting. So all of these issues are issues that you definitely should know about up front. What if the obituary is incorrect? This happens, that the obituary is incorrect. People get left off by accident. If you see an obituary that gets left off by accident, you absolutely, like if you're at the funeral and you're like, hey, wait a minute, you left off one of the children, you should have it edited, because that's a legal document and that's a problem. And if there becomes a dispute over the property, now this is where the big money comes in probate. This is where it's going to cost you a lot of money, because now you have to provide birth certificates and find these people, and it becomes a big dispute and everybody has a lawyer. And the more court dates you have, the more money is going to cost you. So being accurate up front is extremely important, because it's going to save you money on the back end. The other thing is, I've had situations where, somebody was together for a long time. They weren't really married, but they were together. And so they were listed as the person's wife. But it just so happened that they did break up before, but the family wanted to be respectful. So they called her his wife on the obituary, and it wasn't his wife. And we had to then prove that it wasn't his wife in order to sell the property. Just make sure the obituary is correct, because an obituary is a legal document. Okay, next. The cost of waiting. So we talked about this, but the cost of waiting is time is money, and relationships. If you're here today, it's because you understand that estate planning is important. You understand that you need to have a will or a trust or a power of attorney in place. And if you don't have those documents in place, it's going to cost you and your family time, money, and relationships. Why is that important? There are statistics that say by 2053, the median Black wealth will be $0. That's serious, y'all. It is serious. We are losing wealth because we are not planning. And when you don't plan, and people have to go to court and they have to take off work and they have to pay money, sometimes they don't do it. And so they walk away from the assets. Sometimes they wait and the assets waste. So we can't keep waiting and we can't keep ignoring it. So I'll tell you a little bit about what we do. As I mentioned, I'm Ebony Lucas. I'm a real estate attorney. I do real estate. I help people build wealth through real estate and keep it through estate planning. If you're under contract right now to buy a house, you need a lawyer who is also going to do your estate planning for you. It is important. Step one, when you come to us, because I see some questions about what does the process look like? How does this work? When you come to us, the first thing we do is we give you a consultation. We hear what assets you have. I heard the young lady just say she has a business, she has a home, she has an investment property. You have all these things, and we'll talk about what structure should it go into. Is your business properly structured? Who is the owner of your LLC? Is it you or is it the trust? We talk about all of those things to make sure that that we understand what your situation is. This is another reason why you want to be careful about using those DIY apps. I know we all like to do things on our own, and I think it's fine to do it on your own as long as you understand what you should be doing and how to do it. Step 2 is that after we talk to you, we then design your plan. Then we have a signing session where you come in, we review your plan, you sign it, and then we do the next step, which is the funding of the trust. Because remember, your trust is not valid until it's funded. So we make sure that your trust is funded properly. And then as life changes and you need updates, we make sure that you do that. Because here's the thing, estate planning is not just documents. It's not just putting papers together. It's not just worrying about when you pass away. As we already talked about, this is for while you're alive, it's for when you pass away. It is a generational wealth strategy. And then we're going to talk about closing the wealth gap. If we're going to talk about building wealth and passing down generational wealth, we can't do that without estate planning. So next steps, you're here tonight. We've been on a call almost an hour, so I don't want to take your whole evening. I know that it's getting late, but you work too hard to build your life without a plan for what happens to it. And I'll admit my fault in this. I started my firm in 2009. Since 2009, I've represented over 3,500 people. And I only did estate planning previously when people asked me to. And now what I've learned is that this is too critical to wait for somebody to ask me to do it. Because these are hard conversations, and sometimes people don't know to ask. Sometimes people are afraid to ask. They're embarrassed to ask. So I'm talking about it proactively and saying, if you own a home, this is a must. You worked too hard. So let's talk about the next steps. The next steps are, you want to start your estate planning by first reviewing your goals. Take a look at what your goals are. What are you planning to do moving forward? Who's a part of that? When you talk about your trustee, like a lot of times people immediately think that, oh, if I don't have a child, if I don't have children. Well, if you don't have children, if you don't have family members, maybe there's a charity. What you don't want to do is just walk away from your assets and give it to the state, because the state then can't do anything with it. They just hold on to it and let it waste. And now you work for nothing. But if giving to a charity means you get a plaque on the wall, at least people remember you for that. So, reviewing your goals. What are your goals? How do you want to protect your family? Who in your family is important to you? Who in your family is competent to serve as your trustee? And if there's no one, there are companies out there that actually serve as trustees for people. There's Northern Trust Bank. There's companies out there. It doesn't have to be a person. So if you're not comfortable with anybody that you know, that's okay. Then we work with you. You want to work with an attorney. Create a customized plan based on your situation. Our firm actually has flat fee pricing. I know there's some questions about it. One of the questions, do I have to be under contract to acquire your services? The answer is no. We do just the estate plan. If you already own a home, or even if you don't have a property, sometimes we have people come to us and they don't have a property, but they have money in the bank. They have a retirement plan. They have a brokerage account. Any of those things, remember, any one of those things means that you have an estate. You have a business, but you don't own a home yet. You have something to leave to people. You have something of value. We're happy to work with you. Next slide. So if you're ready to get started today, I'm running a special just through tomorrow. And we have had an amazing response on social media for the content that we've been putting out there about estate planning. I see that there's a need. I see that there is a demand for this service. So I want us to have it. I want people who look like me to have their affairs in order. So scan the QR code, use the link that's at the bottom of the screen. Our package that we're offering through tomorrow is normally $3,500. Today and tomorrow only, it's $2,500. It includes your trust. It includes your pour over will, which is only going to have those things that are maybe clothes that you buy a week before you die. Everything else is going to be in the trust, and your trust is going to be properly funded. One of the questions, does your trust have to be funded yearly? Your trust has to be funded every time you buy a new asset. So if you're a real estate investor and you're buying property yearly, then yes, every time you close on a property, we want to update your trust and add that. Now, you don't need a lawyer to do that. So what we do when we do your estate plan for you is that we actually give you a whole page in the back of the document. And that page is so you can add assets as you receive them. So if you go and you buy another property, you just have to remember, make sure you put that property in the trust. If you need help with that, we obviously help you do the new deed, but you're fine with just writing on the back of the trust, you know, I bought a new property and here's what the address is. A financial power of attorney and a healthcare power of attorney. I'm going to talk real quick about power of attorneys because I haven't said this yet, and I know we only have 10 minutes left, and I do want to leave time for questions, but a power of attorney dies with the person. So if someone has a power of attorney, and that is the only document that they have, after they pass away, it's no good. You need more than a power of attorney. A power of attorney is not enough. No, you have one trust for your properties. The question is, are you doing a separate trust for each property? No, it's one trust. All of your properties are in that trust. If you want to do a separate LLC for the properties, you can do that. And then you name the trust as a beneficiary, but you have one trust. And that avoids confusion. And then we help you with your trust funding guidance. Not only do we just help you with your trust funding guidance, we help you with having the conversation, because you need to have conversations with your family about what you've decided to do, what you've decided to pass on, who's in charge. People need to know this before you pass away. They're going to find out anyway. And a lot of times people are like, well, I don't want to make someone mad or whatever, but it's better to have the conversation now than when people are grieving. People get along if they understand that this is the decision you've made and this is how it's going to be and it's in writing. They'll get over it. So if you click on the link and you decide that you want to work with us now, then your payment secures your webinar pricing and starts your onboarding process. You'll get a link from us by tomorrow, and that link will have the information in it for you to actually, as soon as you pay, you're going to go ahead and schedule a meeting, and we're going to then send you an email of all of the information we need for you to get started. Information you need to get started. You're probably wondering, well, what do I need? Property addresses for any properties that you own. Account numbers. So it's, it's almost the middle of the month, but you got your statements in the mail. You need your bank account numbers, your retirement account numbers, your life insurance policies, who those are with. We need all of that information. So you want to start pulling together that information. If you feel like you're not ready yet, it's okay to start pulling that information together before you get started. What you don't want to do is leave today and not do anything at all whatsoever. Even if your first step is just to do the power of attorney. Even if your first step is just to pull those documents together. Even if your first step is just to go to your mom and talk to your mom, or go to your grandmother and talk to your grandmother, or your dad, go talk to your family. Those first steps must happen. There's a question about, do we service people from out of state? We actually have a national network of attorneys that we can draw from. So certainly if you're interested, if you go to the next slide, please. The next slide has my email address on it. If you live in another state, and then we can't represent you because our office can only represent people in Illinois. But what we can do is provide you someone in our referral network. And we have attorneys all over the country that we can refer that are competent and prepared to provide services to you. My website is here. My email address is here. Now, I want to leave the last few minutes for questions. So are there other questions? Clients whose homes are in bankruptcy. So here's the thing about bankruptcy. Just because you file for bankruptcy doesn't mean you no longer own the home. The bankruptcy is not about the property, it's about the debt. So I've had people who filed for bankruptcy and They moved out of their property. They just walked away. And then years later, they're getting tickets from the city and they're like, I didn't think I owned that property anymore. And what happened was the bank may have written off the loan, because that happens sometimes in bankruptcy. So now you're in a situation where you still own this property. So absolutely, bankruptcy does not impact your ownership unless the court says so. Unless the court forces a sale of the property, bankruptcy does not impact your ownership. Someone says, if I already have an LLC and an EIN and haven't done anything with it, can I use it as a part of the trust creation? The answer is no. So your LLC is going to have nothing to do with your trust at all whatsoever, other than your trust should be the member of the LLC, not you personally, because it's just another level of protection. Your EIN number has to be specifically set up for the trust. So when we set up the trust, the EIN number has to be in the name of the trust. When you set up an EIN number with the IRS, they ask you what the EIN is for. We have to say that that EIN is for the trust. This is a great question. I just had someone contact me that has this situation. He has a $4 million settlement from a lawsuit that he's expecting. And the court is saying, hey, we're going to be paying this to you in onesies and twosies until we get it. So he had to now create a trust. And one of the assets in the trust is the lawsuit. If you know somebody that's been in an accident and they might be terminally ill from their injuries in the accident, absolutely. How does that lawsuit continue after they pass away? It continues because the lawsuit is an asset that can be placed in the trust. So yes, lottery money, lawsuits should be assets that are placed into the trust. Great question. Thank you. I currently own 2 different trusts for 2 different properties. Okay, I think what the person is talking about is a land trust. A land trust is another type of trust. A land trust is not an estate planning document. It is a holding document. So a land trust will allow you to pass on the property to someone, but it only passes on the property. Now, have any of you can do the reaction or tell me in the comments, heard of someone passing away and the family members coming into the house, or maybe even not family members coming into the house and taking items? They take the TV, they take the clothes, they take the shoes. You heard of this happening? They take the purses, whatever they come in and take. A toady, a land trust, those documents are sort of partial documents. All they do is pass down the property. They don't pass down the assets in the property. And everyone wants to think, oh, my family would never do that. We love each other way too much. Nobody would ever come and take my grandmother's couch when she passes away. And then it happens because you had a toady, because you thought that was enough. And guess what else a toady doesn't cover? A toady doesn't cover incapacitation. You have a heart attack, you have a stroke. Again, we have to think about we have to think about this as a generational wealth strategy. And when we think about the strategy, we don't always think about worst case scenario. Death is worst case scenario. What happens before death? Maybe it's a heart attack. Maybe it's a stroke. Maybe it's a car accident. It could be any number of things. Maybe it's some other type of illness, cancer, and you just need help for a little while. And you're not able to say you need that help. Who is making those decisions? A toady doesn't talk about that. A land trust is only for the property. It is not for everything else. We're talking about doing a revocable living trust or an irrevocable living trust. And if you would like, you can make that trust the beneficiary of your land trust. Let's see, I have some other questions. I'm sorry, the comments are moving quickly. Yes, do you offer any deal if I sign up for myself for a trust as well as sign up for my parents? Yes. So we are offering $1,000 off right now. That's our deal that we're offering. Oh, somebody said, what's the total? I'm sorry. So yes, we are offering $1,000 off right now. If you need a payment plan, when you go in to pay, I believe it gives you an option for that. So you will have an option to do a payment plan if you need to do that. A TODI. A TODI is a transfer on death instrument. So you may have seen people say, oh, just put it in a transfer on death instrument. A TODI or a transfer on death instrument only transfers the property, the house itself. It doesn't transfer anything within the house. It doesn't transfer bank accounts. It doesn't do any of these things. Now, a lot of people think that a trust, the first thing people say, well, a trust is more expensive than a will. The only additional cost between a trust and a will is going to be the cost to record your deed. That's the only additional cost upfront. Now, again, your trust, just like your will, you need to update it over time. So there are other things that you have to do, but there really isn't any major additional cost to it to have the level of protection that we're talking about having. Okay, well, it is 8 o'clock. And I provided my contact information. If you have other questions, please feel free to give me a call. I look forward to working with you. And we actually also have a free estate planning guide on our website. So feel free to go on there to get more information. I want you to come with me and let's start thinking about generational wealth. Let's think about generations not starting over again. Let's think about leaving a legacy. And that doesn't have to mean children. It doesn't have to mean family. It could mean charities. I want to walk in places and see your names on plaques. I want to walk in places and we want to remember that you were here, and we don't want you to lose money and your family to lose money when you pass away. So thank you so much for giving me your time this evening.